My name's Tim Monsees. I'm the senior and founding partner, or in our case, a shareholder of Monsees and Mayer Law Firm. We're a plaintiff's personal injury firm, meaning that we almost always represent the person who's either been injured or somehow victimized by wrongful conduct of someone else. I'm going to chat with you a few moments about what's called a deposition. It's the opportunity that the opposing attorney has to ask you questions about what you know about your case, how it happened, how it's affected you. It also is an opportunity, if you're an employed person, they may ask you questions about your employment history. They may ask you questions about other people that you're related to in town, which will affect jury selection. But at the end of the day, a deposition is little more than a conversation. So what are the rules? How do we guide ourselves in a deposition to make sure that we're doing the right thing and giving ourselves the right chance to win our case? Well, the first and foremost rule is simply be honest. Honesty is not something that should even be in question, and dishonesty is certainly something that as a lawyer I can hardly ever recover from as your attorney in trial. Dishonesty is a deal breaker, no matter how much merit your case otherwise may have. So honesty is the first and the foremost rule, and just trust that anything that you say that is inaccurate or dishonest, chances are good to excellent in my now 42 years of experience that the other side's going to find out about it. So the next thing that you need to consider when going into a deposition is don't guess. Guesses get you into trouble. Guesses get me into trouble in trying to be the best advocate for your case. It's okay to say, I don't know, or I don't remember the answer to a given question. But bear in mind that there's a difference between those two. I don't know suggests I never knew the answer to this question, and chances are good, unless somebody tells me, I am never going to know the answer to the question. By contrast, I don't remember suggests, I think I used to know the answer to this question, but I can't think of it right now as you're asking me these questions. Later you may recall, and that's an easier position to recover from than to say a blanket, absolute, I don't know. The next thing to remember is don't volunteer any information. Volunteering information invariably gets you into trouble and makes my job more difficult. So for example, if you have a car wreck case and the question from the defense attorney is, did you see the stop sign before you entered the intersection? The answer is simply, yes, I did, or no, I did not. Getting into tangents and volunteering information like, yeah, I was about 100 feet away from the stop sign and I was approaching it and I saw a green car coming from the right. That's a lot of information that wasn't demanded by the question. Leave it to the defense attorney. Most of the people we deal with are very good attorneys. Make them do their job. Make them think of the questions to ask you. The more information you volunteer, the easier you make the job of the defense attorney. The next thing you may want to remember is, at the end of the day, some of this is just a popularity contest. I know that sounds a bit cynical, but what happens with the defense attorney, every time they take your deposition, they go back and they report to their client, whether it's an insurance company or it's some other company, and one of the first things they'll tell that company is, Bill makes a wonderful witness. He's going to be such a great advocate for himself in front of the jury. The jury's going to love him. If by contrast you're argumentative, you're combative, you're insincere, those are emotions that are also going to be reported back to the defendant when they decide whether they're going to settle your case and for how much. So be likable, be yourself. That extends to how you dress. How should you dress in the deposition? I always tell my clients, and I'm telling you, dress for who you are. Don't try to be someone you're not. If you're a business person and you typically wear a coat and or a tie, do that at your deposition. If you're a laborer and you have work clothes, as long as they're clean and neat and you're going to be comfortable in those work clothes, that's okay too. The most important thing is when you get to the deposition, you're as comfortable as you possibly can be, and that extends to how you feel in your clothes. At the end of the deposition, you're going to be given the option to review and sign your deposition. You're reviewing it to make sure that there are no errors, either in how the court reporter, who will sit next to you during the deposition, taking down every word that you say and every question that's asked. You want to make sure that you were absolutely recorded properly in your answers to the questions. You also may have some limited opportunities to change the substance of what you said, so that if you remembered seeing a car that was red and you later recall that the car was blue, you can make that change. realizing, of course, that they now have a contrast between those two. But it's more important, remember rule number 1, be honest. If that's what's needed to correct your deposition, that's what we do.